Your home is your castle, but what powers do the police in England and Wales have when it comes to entering and searching your property? And do they need a warrant? Hello, I'm Barrister Daniel Barnett. In this video I'm discussing the police's power to enter and search your home. Now, nothing in this video is meant to encourage you to impede the police in the execution of their duties. Always follow any lawful instruction from a police officer. The police don't have any general right to enter your home without your permission. Normally, to enter your home without permission, they need a warrant. But the police also have powers which allow them to enter and to conduct a search of your home without a warrant in particular circumstances. The situations are actually far more common than you might think. The police will often ask permission from the homeowner or the person in control of a property before seeking a warrant. If permission's refused, or if the police don't want to ask in advance, they need to obtain a warrant in most situations, and they do so by applying to the Magistrates' Court under Section 8 of the Police and Criminal Evidence Act 1984, known sometimes as PACE. They must be investigating a serious offence and must have reasonable grounds to believe that there's important evidence within the property. The court will only grant a warrant where the police have reasonable grounds for believing that an indictable offence has been committed and that there's material on the premises which is likely to be of substantial value to the investigation of that offence, and that material is likely to be relevant evidence, and that it doesn't consist of or include items subject to legal privilege, such as communications with your lawyers, and that any one of the conditions I'm about to describe applies. The conditions that have to apply, or at least one of which has to apply, are a list of scenarios where the police might need to get a warrant for access to a property. They include when it's not practicable to speak to the person who would be entitled to grant police entry, i.e. the owner. They include where entry won't be granted without a warrant, so that covers cases where a person might have previously refused entry or is generally uncooperative, or where the purpose of the search might be frustrated or seriously prejudiced unless the police can immediately gain entry. In short, warrants for entry are only granted to police, and only really needed, where they can't otherwise get access, or where their investigation makes it necessary to enter without asking permission first in order to catch someone or secure evidence. But there are also a number of situations where the police are entitled to enter without a warrant. Let's have a look at those. The police are allowed to enter a person's house or property without a warrant or any prior permission in certain cases. These include with permission from the homeowner, if police are invited in by someone who's entitled to grant entry. Obviously, they don't need a warrant. That doesn't cover a young child, by the way. For the purpose of executing an arrest warrant, for example, if a court has issued a warrant for someone's arrest if they fail to turn up at court. Police can also enter a property to arrest someone who's suspected to have broken their bail conditions. 3. To find or arrest a person suspected of committing a serious offence. This refers to indictable offences, which are generally only the most serious crimes, which would be heard in the Crown Court. Police are also allowed to enter to arrest a person for certain other offences, including public order offences or drink driving. 4. To address a breach of the peace. For example, in response to a disturbance, or if the police are responding to cries for help or distress. Now, that makes sense, of course, because in that sort of situation, the police just aren't going to have time to go to a magistrate's court, assuming one's even open, and seek a warrant. 5. In an attempt to save a life or prevent injury to someone or prevent serious damage to property. Now, this is often invoked by the police who've received calls from distressed children or family members claiming they're at immediate risk from domestic violence. For many of the above reasons, police would need reasonable grounds to believe that the person they're searching for is actually on the premises before entering the property. Once police have entered your property using one of these justifications, they're usually allowed to conduct a search. Now, this is most common when they're entering to investigate or arrest someone on suspicion of a serious offence. They can also seize evidence which is relevant to the investigation when they search the property. If you are arrested at home, police can search that premises in order to find evidence in connection with the offence. They can also seize those items as evidence. There are certain things the police must not seize when searching, for example, letters from your lawyer giving legal advice. It's helpful to remember that most of the powers to search and enter, both with and without use of a warrant, are subject to the PACE, the Police and Criminal Evidence Act, codes. They're rules which the police must adhere to. And you're entitled to check these for yourself to make sure the police are following the proper procedure. Remember, nothing in this video is an encouragement to impede the police in the execution of their duties. If you found this video helpful, here are some more criminal law explainer videos, here are some videos on family law, and this is a video I think you might like. I'm Barrister Daniel Barnett. Thank you so much for watching. Bye bye.